Trump couldn't pay $450 million, maybe now he can pay a mere $175 million. Donald Trump famously crowned himself the king of debt.
Nobody knows more about debt than I do.
Well, he probably didn't mean it like this, because at the moment, he's staring down a mountain of pain, over $600 million in judgments, fines, penalties, and interest. And it's getting worse every day. Every day that passes means about $100,000 more in interest. Now, as you probably know, on February 16th, New York Judge Arthur Engoron ordered Trump to pay $355 million plus $98 million in interest in fraud damages for manipulating yearly financial statements to obtain favorable loans and insurance premiums for the Trump organization. This came weeks after a jury in a separate civil case in New York federal court ordered Trump to pay $83.3 million for defaming writer E. Jean Carroll. And that's on top of the $5 million that Trump was ordered to pay in a separate defamation case of Carroll's. So facing over $500 million in judgments and his entire business empire at risk, this will be a test of Trump's decades-long superpower of weaseling out of any actual consequences for his actions. But today we're going to answer the question that's on everyone's mind: how is Trump going to pay for these judgments? Or at a minimum, how is he going to get a bond to stay execution of these judgments pending the outcome on appeal? Can his supporters or the Republican National Committee pick up the tab? Could a random billionaire? I don't know, I'm not thinking of anyone in particular. And what if Trump just refuses to pay? So with judgments and deadlines looming, Trump has some big decisions to make. The first procedural step is the post-verdict entry of judgment. After the judgment is finalized, step 2 is posting a bond and filing an appeal. If a bond isn't posted or Trump exhausts all of his appeals, then we go to the final step, collections and enforcement of judgment. So let's dig a little deeper. On February 8th, Judge Lewis Kaplan finalized the $83.3 million Carroll judgment. Trump had 30 days in both the Carroll case and the New York fraud case to appeal in an effort to lower or overturn the amount awarded. As a result, Team Trump had been fighting to stop the clock in both cases with mixed results. In a February 21st letter to Judge Engoron, Trump's lawyers accused Attorney General James of being in an, quote, unseemly rush to memorialize the judgment and requested a 1-month delay in finalizing it. In an emailed response to Trump counsel Clifford Robert, Judge Engoron curtly denied the request, quote, "You have failed to explain, much less justify, any basis for a stay. I'm confident that the appellate division will protect your appellate rights." On February 23rd, the county clerk signed the Trump civil fraud judgment, making it official. That same day, Trump's lawyers filed a motion requesting a stay of the latest Carroll judgment for at least 30 days after, quote, forthcoming post-trial motions, which will be filed no later than March 7th. In the 21-page filing, Trump's lawyers argued that the $65 million damages award and the $18.3 million in compensatory damages was plainly excessive in violation of the Constitution and federal common law. Quote, "There's a strong probability that the disposition of post-trial motions will substantially reduce, if not eliminate, the amount of the judgment." Judge Kaplan denied the stay while inviting Carroll to respond as the 30-day clock to appeal continued to run. So let's dive into what's happened in these appeals. The Carroll cases are in federal court, so any appeal would be heard by the Second Circuit. And in the state fraud cases, Trump could appeal to the appellate division and then to the New York Court of Appeals, which for reasons that are beyond my understanding is the highest court in New York, whereas the Supreme Court of New York is the lower trial court. It is theoretically possible that Trump could appeal at least the Carroll cases to the US Supreme Court, but that's extremely unlikely. The various courts of appeal give great deference to the lower courts and likely would only disturb the factual findings of the lower courts if they are, quote, clearly erroneous. And given the detailed factual findings of these cases, that would be a very heavy burden for Trump to climb. So Trump is likely to focus on issues of law and constitutional interpretation because appellate courts review these issues de novo, meaning that they give no deference to the rulings of the lower courts. But you can ignore all of that procedural stuff because here's the most important thing that you need to know. Under New York law, a person must first secure an appeal bond or place a cash deposit that amounts to 110% of the judgment in order to stay the enforcement of the judgment during the appeals process. Now, technically, you don't need to post a bond just to appeal. You can do that for free. But you do if you want to temporarily postpone the enforcement of the judgment, which is the thing that most people really want to stop, at least while their appeal is pending, though they'd like to stop it after their appeal is done, but at that point they don't have a choice. After all, if you win the appeal, it would have been really unfortunate to sell off all your personal belongings to satisfy the judgment only to try to claw that back after you win the appeal. And on the other hand, the deposit ensures that the appealing party pays if they lose, while protecting the court from frivolous appeals or bad faith delays. Now, following the first Carroll verdict, Trump gave the court a cash deposit of $5.6 million. But for the second Carroll verdict, Trump opted to secure an appeal bond instead. After his initial efforts to stay the judgment failed, Trump posted a $91.6 million bond from Chubb's federal insurance company on March 8th. So while Carroll is now prevented from immediately collecting either award, Chubb is now contractually obligated to pay Trump's $91+ million award if Trump loses the appeal and fails to pay. So that's a really good position for Carol to be in. She's guaranteed to get paid if she wins the appeal. So while a lot of people wanted Carol to force Trump to sell off some real estate to pay the judgment, she's in a much better position having a guaranteed payout. And in that situation, Chubb becomes subrogated to Trump. If Chubb pays out the $91 million, they can then go after Trump himself. Chubb CEO Evan Greenberg said that providing a bond, quote, has nothing to do with the underlying merits or with favoring any of the parties in this case. As a surety, we don't take sides. It would be wrong for us to do so, and we are in no way supporting the defendant. Greenberg also said that the bond is fully collateralized and that the company can be made whole if necessary. And reports are that the $91 million bond is collateralized by Trump's Schwab account, likely full of very liquid assets like cash or stocks. So if Trump loses and Chubb pays out, it's extremely likely that Chubb will be able to recover 100 cents on the dollar by just liquidating Trump's bank account. But foreshadowing, that's not the case for the fraud judgment. And for the fraud case, Trump would need a bond of more than $540 million at a cost of around 1 to 3% of the bond amount. And more foreshadowing, it's likely that the main other assets that Trump has are commercial real estate. But you might have noticed that ever since the pandemic, nobody really wants commercial real estate. And now Trump has been granted a reprieve. On March 25th, a 5-judge panel of New York's appellate division reduced the bond amount and stayed other provisions of Judge Engoron's order. The appellate judges reduced the bond by 60%. The order says, quote, it is ordered that the motion is granted to the extent of staying enforcement of those portions of the judgment. 1, ordering disgorgement to the Attorney General of $464 million, conditioned on defendant appellants posting within 10 days of the date of this order an undertaking in the amount of $175 million. 2, permanently barring defendants Weisselberg and McConey from serving in the financial control function of any New York corporation or similar business entity. 3, barring defendants Donald J. Trump, Weisselberg, and McConey from serving as an officer or director of any New York corporation for 3 years. 4, barring defendant Donald J. Trump and the corporate defendants from applying for loans from New York financial institutions for 3 years. And 5, barring defendants Donald Trump Jr. and Eric Trump from serving as an officer or director of any New York corporation in New York for 2 years. The enforced stay is conditioned on defendant appellants perfecting the appeals for the September 2024 term of this court. Now, what circumstances justified such a major departure from the judgment? The order doesn't include any legal reasoning, but we can assume that the court agreed with Trump that he'd suffer irreparable harm if he was forced to sell his babies, which is what he called his properties over the weekend, not his children. Which does make some sense because if the state seized Trump's properties and sold them, he wouldn't be able to get them back even if he won the appeal. So that was likely enough for the court to rule in his favor. But where did the $175 million figure come from? Well, we have no idea. The court probably wanted Trump to be able to post a bond, and the vibe suggested that he could come up with a bond in that amount. So now Trump gets 10 days from March 25th to post the $175 million bond, and Trump quickly thanked the appellate judges for their hard work.
So I greatly respect the decision of the appellate division, and I'll post either $175 million in cash or bonds or security or whatever is necessary very quickly within the 10 days.
Now that's a lot less than the $500 million plus that he was going to have to put forward before, so maybe he can do it. Though Trump represented to the court that no one would accept real estate as collateral for a bond except for Chubb, but it is possible that this amount is high enough that he still needs to use real estate, which, if what he said was true, then he'd have to go back to Chubb. Now, before the appeals court saved the day, Trump appeared to be in hot water for publicly stating things that contradicted his legal filings. His legal team told the court that he didn't have the cash to put up the bond and had to ask for surety companies, and they all said no. But on Truth Social, Trump said he did have the cash, but he didn't want to use it because instead he was saving it for his presidential campaign. Quote, through hard work, talent, and luck, I currently have over $500 million in cash, a substantial amount of which I intend to use in my campaign for president. Now, having a client directly contradict your sworn statements to the court is every lawyer's worst nightmare. People who work for the Trump Organization, including Chief Financial Officer Alan Garten, submitted declarations to the court swearing under oath that Trump does not have the financial means to post a bond of 120% of the judgment. And since Trump contradicted the official declarations, a court could have and might still have accused the officers of the Trump Organization of submitting false statements to the court, which would never be a good look. The Trump merger was approved and Trump's share could be worth billions if he's allowed to cash out. Now, lockout rules generally prevent the large shareholders from doing so, but it looks like those rules could be relaxed by the board, which is controlled by Trump and his cronies. So it's entirely possible that he could change the bylaws, cash out, and tank the stock while lining his pockets. But this is Trump we're talking about. He'd never do that, right? And while you might remember that Trump's fraud judgment barred him from obtaining loans from any financial institution chartered by or registered with New York, that part of the order was put on hold by the appellate division on February 28th. So we don't know how much liquid cash Trump has, or if he has enough to cover the judgments or the bonds. It would be exceedingly difficult to turn his real estate into a bond and eventually to satisfy the judgments, which leads to the possibility of just some other billionaire footing the bill here, especially given a very interesting flight that Elon Musk took to Palm Beach not too long ago. And yeah, there's no law against third parties paying your judgment for you, even a judgment worth $500 million. Though I do wonder about the tax treatment of a third party satisfying your judgment on your behalf. It kind of seems like that would be treated as income by the IRS, meaning that you'd have to pay taxes probably at the top marginal rate on the entire hundreds of millions of dollars, which would mean you'd still owe hundreds of millions of dollars of taxes, even though the original hundreds of millions of dollars were satisfying the judgment. But we'll cross that bridge when we get to it. So far, it doesn't seem like there are any billionaire takers, much to the chagrin of some commentators. Now, if you've defrauded the state of New York, you'll need a good lawyer. But if you want a great lawyer, my firm, the Eagle team, can help. If you've had an injury or death in the family, suffered a data breach, especially if you got one of those privacy letters, or were involved in a car crash, we can represent you or help find you the right attorney. It's so important to talk to a lawyer early in the process so you can learn what your options are and maximize your recovery. So just click on the link in the description or call the number on screen for a free consultation with my team, because you don't just need a legal team, you need the Eagle team. So click below. But then there's the possibility of the Republican National Committee, Trump's campaign, or his super PACs helping him out. As of February 2024, Trump's Political Action Committee, Save America, Trump's presidential campaign, and his other fundraising organizations have spent $76.7 million on his behalf in legal fees over the last 2 years. And while it is a giant open question whether he's allowed to do that, Trump would likely be barred from using those same funds to pay actual legal judgments. Under federal law, candidates are prohibited from using campaign funds for personal use. And to differentiate between legitimate campaign expenses and personal expenses, the FEC applies the irrespective test. And under that test, personal use is a use of funds to fulfill a commitment, obligation, or expense of any person that would exist irrespective of the candidate's campaign or responsibilities as a federal office holder. Now, Trump has claimed that these witch hunt lawsuits and prosecutions are politically motivated, allowing him to use campaign funds for the legal fees. And because the FEC has basically been destroyed from the inside, that statement hasn't really been challenged. But it's pretty clear that he could not use campaign funds to satisfy the judgments. Judge Kaplan has previously ruled that Trump's defamatory statements in the Carroll matter were not within the scope of his presidential duties. And the civil fraud judgments relate to conduct unrelated to him being president of the United States. But what if Trump decides not to pay at all? As we know, Trump has a long history of not paying his bills, whether they're contractors, cities that host rallies, or Rudy Giuliani. So what happens if Trump just refuses to pay? Well, if a party fails to have the appellate court stay the judgment or loses their appeal, the judgment is enforceable. And at that point, the state could levy and sell his assets, they could put a lien on his real property, or they could garnish his future income. And a few days after the verdict, New York AG Letitia James told ABC News that she was ready to seize the former president's assets if he's unable or unwilling to pay the judgment. Quote, "If he does not have funds to pay off the judgment, then we will seek judgment enforcement mechanisms in court and will ask the judge to seize his assets." And while the case against Trump and his businesses is relatively novel, seizing a defendant's assets to pay a judgment is a common legal tactic for both state and private actors. For example, O.J. Simpson's Heisman Trophy was famously seized and sold at auction in 1999 after the families of Ron Goldman and Nicole Brown Simpson won a $33.5 million wrongful death lawsuit against the ex-football player turned murderer. So both the state of New York and E. Jean Carroll could also attempt to seize Trump's assets and pay their respective judgments. And in addition to asset seizure, failure to comply with a court order to pay could result in someone being held in contempt and hit with additional fines. Imprisonment for non-payment of judgment is technically possible, but it's not likely. Now, if Trump can't raise the funds he needs, there is that one weird trick to halt court proceedings and delay enforcement for years and maybe even get those liabilities greatly reduced, and that is declare bankruptcy. Now, Trump is no stranger to bankruptcy. He has previously filed Chapter 11 bankruptcy for 6 of his failed businesses. This allowed him to stop creditors from collecting while each company reorganized their business and restructured their debts. But the one thing that Trump has never done is file for personal bankruptcy. In Chapter 11 personal bankruptcy proceedings, the trustee and the judge overseeing the case would work to extract the maximum value from the businesses, bank accounts, and other assets, and the court would have to approve any reorganization and payment plan, which could include declaring some debts dischargeable, meaning that the debtor is no longer liable for the amount due. However, the bankruptcy court could block Trump outright from discharging at least the Carroll defamation judgment. For example, in October 2023, a Texas judge ruled that Alex Jones could not discharge over $1 billion in defamation judgment debt because the bankruptcy code excludes debts incurred as a result of willful and malicious conduct. And as for Trump's fraud judgment, Section 523 of the Bankruptcy Code exempts from discharge any debt for money, property, services, or an extension, renewal, or refinancing of credit to the extent obtained by false pretenses, a false representation, or actual fraud. And there's a reasonable argument that that provision would apply to the New York civil fraud judgment. So Trump now faces a March 25th deadline to post a bond for over 100% of the judgment to put it on hold while he appeals. If he can't post a bond, the appeal will still move forward, but the New York Attorney General can begin enforcing the judgment. Though the Trump Organization, in a plea for mercy, has detailed how hard it has been to try to get a bond. Quote, defendants have devoted a substantial amount of time, money, and effort toward obtaining a bond for the judgment. Despite the foregoing, defendants have faced what have proven to be insurmountable difficulties in obtaining the appeal bond for the full $464 million. Critical among these challenges is not just the inability and reluctance of the vast majority of sureties to underwrite a bond for this unprecedented sum, but even more significantly, the unwillingness of every surety bond provider approached by defendants to accept real estate as collateral. The company has apparently approached more than 30 surety companies proposing to pledge as collateral a combination of cash or cash equivalents and unencumbered real estate holdings, but there were no takers. Probably because most brokers don't have the financial resources to handle a bond of such magnitude, and those willing to do so are unwilling to accept the risk associated with such a large bond. And that includes Chubb, the insurance company that provided Trump's $91.6 million appeal bond in the E. Jean Carroll civil defamation suit. And according to the Trump Organization, Chubb was negotiating with Trump to post a bond, but the company changed its mind after the news of the Carroll bond became public. And then Chubb apparently told the Trump defendants that they could not accept real property as collateral. And that's the biggest problem that Trump has. He needs cash. His reply brief in support of the stay application says the bonding companies will not accept hard assets such as real estate as collateral, but will only accept cash or cash equivalents such as marketable securities. But I mean, come on, guys. Trump is good for it, right? Moreover, they complain that sureties would typically, quote, require collateral of approximately 120% of the amount of the judgment, which would require defendants to hand over collateral in the form of cash or cash equivalents of approximately $557 million. And the defendants argue that courts routinely waive or reduce bond requirements when securing the bond is not practicable, and that's exactly the scenario that they find themselves in now. They accuse Letitia James of being ignorant of the practical realities of running a business, saying that she, quote, speculates without evidence, and revealing her misunderstanding of basic business practices that sureties might accept an irrevocable letter of credit as collateral. But any such ILOC would still typically have to be fully backed by cash or cash equivalents. Obtaining such cash through a fire sale of real estate holdings would inevitably result in massive irrevocable losses, textbook irreparable injury. Which is why such a fire sale is Trump's worst nightmare.
Prized properties such as Trump Tower, iconic properties like 40 Wall Street, to pursue his appeal is manifest injustice, and it deprives him of that due process that we are all entitled to. So imagine you can't reverse selling off Trump Tower on a fire sale at a discounted price. We can't fix that if we win on an appeal. So it's complete injustice.
Though in that same interview, for some reason, she didn't rule out the possibility that they had looked to Russia or Saudi Arabia for backing.
Is there any effort on the part of your team to secure this money through another country, Saudi Arabia or Russia, as Joy Behar seems to think?
Well, there's rules and regulations that are public. I can't speak about strategy.
Now, you'll know that the correct answer there was just no. Just the worst lawyers. But the state has pushed back on Trump's claim that James wants a fire sale on Trump properties. In its surreply to Trump's motion for a stay, the state says that many of Trump's properties are encumbered by huge mortgages and the state has no interest in taking those on. Quote, defendants object to a possible fire sale if they were to sell assets to generate cash to use as collateral for a bond or as a deposit, but the alternative would be to shift the risk of executing on defendants' illiquid assets to OAG. And how encumbered are those properties? Well, probably extremely encumbered. Lisa Rubin points out that Axos Bank's loans to Trump for Trump Tower's commercial portion and the Doral Golf Course are much bigger than Trump originally claimed. Both loans are listed as over $50 million on Trump's August 2023 Office of Government Ethics Disclosure, but according to the Washington Post, those loans are for $100 million and $125 million respectively. So the state could force a foreclosure sale on Trump Tower, but the proceeds would have to pay off those loans first. And if there's any money left over after the lien holders are paid off, then it will be used to satisfy the judgment. But James says that the state isn't eager to take on the debt associated with Trump Tower. Quote, if defendants were truly unable to provide an undertaking, they at a minimum should have consented to have their real estate interest held by the Supreme Court to satisfy the judgment. As James notes, the rules allow the court to hold the assets in something resembling escrow, which makes sense. She probably doesn't want to be responsible for trying to sell that real property. Meanwhile, James has lots of other Trump properties to pick from. Although we don't know which ones the state would like to seize first, there are some clues that they'd go for Westchester County. James registered the judgment in Westchester County on March 6th, although the filing didn't identify which assets the state would pursue. Registration allows the state to get liens, and Westchester County is home to some of Trump's most valuable properties, including the Trump National Golf Club, Westchester, and the Seven Springs Estate. And in some of the other videos that we've done, we've discussed the evidence that Trump drastically overvalued Seven Springs. Judge Engeron found that in 2014, Eric Trump had valued the estate at $161 million, even though the appraiser had told him that the development was only worth around $14 million. And I guess we might actually find out what the market thinks it's worth. Now, given Trump's obligations in the E. Jean Carroll lawsuits, he's still on the hook for those bonds, and $175 million on top of those original hundreds of millions of dollars is still a lot of money. And it's unclear whether Trump will be able to procure the funds to come up with a bond for $175 million as well. And if Trump doesn't post the bond and the state of New York starts enforcement of the judgment, it'll be very painful for Trump. New York has broad discovery rules that allow a creditor to do deep discovery into a debtor's finances. And if it were me, the absolute very first thing that I would ask Donald Trump is, hey, where's that $500 million in cash that you claim to have? But the state of New York would be able to subpoena third parties like banks, accounting firms, insurance companies, vendors, and other business associates, which Trump would effectively be unable to stop. And the state could also compel Trump to sit for a deposition where lawyers will ask Trump about his bank accounts, tax returns, and the names of anyone who might owe Trump money. And I'm sure the state would also be looking very carefully at whether Trump has been transferring any assets out of his possession to hide them. Yeah, the Trump team made a whole bunch of sloppy mistakes when they valued their properties. The writing really could have used some help, which they can get with today's sponsor, Grammarly. Now, as a content creator, I have to do a lot of script writing, and as a lawyer, I have to do a lot of writing and translating legal jargon into something more readable, because Grammarly is the AI writing partner that helps professionals write better, not more. It helps you write faster so you can get stuff done and move on with your work without compromising your quality or privacy. Grammarly accelerates your writing process by generating and modifying text instantly on demand. You'll be writing responsive, thoughtful emails and post faster than ever. It's a huge productivity boost. Plus, it's Grammarly, which I've been using for years, so of course it'll help you write better than ever. And unlike other AI tools, Grammarly tailors its output to your unique context. It picks up on key details and incorporates them into whatever you're writing. I can set my voice to be casual and empathetic, for example, if I'm writing to friends, or I can set it to be more direct if I'm writing to enemies, like opposing counsel. And of course, because it's Grammarly, it helps you fix poor writing in the first place. Not that I would ever do that. I can give it prompts to make something shorter, sharper, or more exciting. And one of the coolest features is the AI reply, which instantly creates a reply to your emails that picks up on context and responds and follows up exactly how you would want. It's a huge time saver. And Grammarly doesn't allow third parties to use their customers' data for training generative AI models, and its customers are always in control of their own data. All Grammarly users can view their data associated with their account at any time by requesting a personal data report. You'll be amazed at what you can do with Grammarly. And by the way, Grammarly is free to use and try out. In fact, all the features shown here are free. So sign up and download Grammarly for free with the link that's on screen right now or down in the description. In fact, it really helps out this channel if you use one of those links, even if you sign up for free. So click on the links below today. After that, click on this link over here for more Legal Eagle, or I'll see you in court.